Good afternoon. It is a great pleasure for the Essex Transitional Justice Network to be hosting the 6th annual lecture. It is a pleasure to have Catalina Diaz with us, a person that I know quite well, a friend, a colleague, a person I have had the opportunity to work with, but also a great leading woman working within the peace process in Colombia. We have invited Catalina because we believe it is very important to give voice to fantastic women like her who are really helping to make history possible in a country like Colombia, where we need to definitely get rid of a terrible armed conflict that has been ravaging the country for the last 5 decades. But it is also very important to have a person like her because she has played a pivotal role within the peace process. She has been following up very important conversations in the country around what is possible, what the obstacles are, and I know, because I've been close to her during this time, that she has been one of the voices trying to balance the demands of international law and the demands for peace, which is not always an easy task. So I am delighted to have Catalina here. Catalina is not only the director of the Transitional Justice Unit of the Ministry of Justice in Colombia. She is also a great lawyer from Rosario University. She has a master from Oxford University and also a master from NYU. She has published extensively about issues related to transitional justice and human rights. And she has a very interesting career because she herself has worked for leading domestic and international NGOs, like, for example, Comisión Colombiana de Juristas in Colombia, also, for example, for the International Center of Transitional Justice, and even for the Colombian Constitutional Court. So she has had the opportunity to work with key institutions, having key responsibilities, and now she holds a position in government trying to make possible a peace agreement that complies with international law. The topic of the lecture today will be the challenges of negotiating peace and complying with international law, the experience of Colombia. We will give Catalina 45 minutes to present her lecture, her reflections around these almost 2 years of strong work trying to make this possible. And after that, we have the pleasure to have, where is Camilo? We thought, given that we have also in the room another brilliant Colombian who has also been part of making this history possible, Camila Sanchez, who works for a leading think tank in the country called the Justicia, and who is the person responsible for all that happens on transitional justice there, we thought it would be fantastic to give him 10 minutes to reply to what Catalina is going to be saying. So you're going to hear the government's explanation of what has happened. I'm not gonna, no. But also Catalina's reflection. She's gonna step back and she's going to reflect about this time working towards a possible peace agreement in the country. It's gonna tell you why that is, why that has been possible, but why that complies with international law. And then we're gonna invite Camila Sanchez to comment on what Catalina has said. We will see whether they stand on the same side or whether they don't, and then we will open the floor for questions. I am delighted to have such an audience here today. It is an audience made of brilliant students, brilliant PhD students, but also of brilliant colleagues of mine at the University of Essex and elsewhere, like Rory O'Connell working at Ulster University. We have Charles Abraham, one of the leading litigators in the Kulumani case in South Africa. Well, I could start mentioning each one of you. I'm delighted to have you here because I think this is not going to be an interesting annual lecture, but this is also going to be a unique opportunity for us to discuss, to dialogue, to put questions to Catalina, but also to consider the implications of negotiating peace in a country like Colombia, the complexities of doing that, and the challenges that we face when we try to bring peace to a situation like that. So I'm really looking forward to this. Catalina, thank you so much for being here today. It's a really pleasure to have you here. Thank you so much for accepting the invitation. We know how, all the amount of work you had to leave behind just to be able to be with us here. I know that you are not going to be talking on behalf of the government. Is more her reflection, so I don't want you to take this as the government is saying this at Essex. It is not. This is Catalina Diaz, who, yes, happens to work for the government, but she thinks by herself. And then we would like to finish the day moving towards the room at the corner, where we will have some wine, some canapes, and we will have Joe. Where is Joe? Joe from Escala. At Essex, we have the biggest collection of Latin American art in the UK, and I would say actually in Europe. You correct me, Joe, if I'm wrong. But we are delighted to be able to show you something that matches very nicely the topic today, and is the photographic work of Wilson Diaz through a video that Joe will be presenting, who has done amazing work about child soldiers in Colombia. So it's a nice way to show through photography what we are dealing with and grapple with in the peace negotiations. Catalina, welcome.
Thank you very much, Clara, and I really am very glad to be here. I'm really honored. This is a very big pleasure to be delivering this 6th annual lecture convened by the Essex Transitional Justice Network and the Human Rights Center at the university. I really think, and I have followed your work and the work by the center and by the network over the last years, this is one of the most important and leading think tanks and centers for the production of knowledge on human rights and transitional justice. So I'm really happy to be here, to be sharing these reflections with you. I really want to thank you, Clara, for this invitation, and I want to thank you, Lorna McGregor and Sir Nigel Broadley, for this invitation. It's an honor, it's a pleasure to be here. So for the sake of clarity, for being concise and meeting the time, I decided to write the paper, actually. So I'm going to read. I really hope this is not going to be that boring. And then we can, of course, have the conversation and discussion. So on the 15th of December 2015, the official delegation to the negotiating table of the National Government of Colombia and the Revolutionary Armed Forces of Colombia People's Army, better known by its Spanish acronym FARC-EP, made public the draft agreement on point 5 of the agenda, victims. The parties had already reached preliminary agreements on other 3 points of the agenda: integral rural reform, political participation, and the solution to the problem of illicit drugs. As we speak, the negotiating table is finalizing the agreement on the end of the conflict, which includes the bilateral and definitive ceasefire, the deposition of weapons and reintegration of FARC ex-combatants, and the agreement on implementation, verification, and endorsement. The signing of the final agreement is expected to be before the end of the semester. The parties already agreed to adopt it as a special humanitarian agreement according to Common Article 3 to the Geneva Conventions. The Havana Peace Agreement will thus put an end to the longest internal armed conflict of the Western Hemisphere with the oldest Marxist guerrilla in the world. The agreement on victims is a turning point in the field of transitional justice. That's what I want to demonstrate. This is the first time that within a peace negotiation putting an end to an internal armed conflict, the parties agreed to the creation of an integral, and I quote, integral system on truth, justice, reparations, and non-repetition, which includes not only the creation of a truth commission, but judicial accountability for international crimes and gross human rights violations. The parties agreed to the creation of a special jurisdiction for peace, composed by a special tribunal for peace and other so-called chambers of justice, including an amnesty chamber. Several peace agreements have provided for the establishment of truth commissions, as was the case in El Salvador and Guatemala in the mid-90s, and in Sierra Leone, Burundi, Nepal, and Kenya during the last decade. However, peace agreements to date have not created specific fora for criminal accountability. The Colombian Accord on the Integral System of Truth, Justice, Reparations, and Non-Repetition could be seen as the materialization of the idea advanced in the field of transitional justice that it is actually possible to reach a peace agreement and at the same time to honor the duty of the state to investigate, prosecute, and punish international crimes and gross human rights violations. The Colombian president chose then a specific formula to solve the so-called peace versus justice dilemma. How was this agreement possible? Which were the key factors and possibility conditions that made it possible? Where does the necessary compromise lie? I will first explain the agreement in certain detail, highlighting the points which, in my opinion, work as conditions of possibility of the agreement. The elements that, in my view, are the key to having achieved a formula making criminal accountability and political honor compatible. I will then proceed to identify other more contextual factors that, from my perspective, contributed as well to making the agreement possible. So, on the agreement, finding a formula for the peace versus justice dilemma was a major challenge. It was extremely difficult. While the negotiation of the first 3 points of the agenda took 6 months each in average, finalizing the agreement on how to address victims' rights took a year and a half. It also required the involvement of a special ad hoc negotiating commission, which became known as the Jurists Commission, in order to finalize the agreement. It was a long and difficult journey. Since the beginning of the negotiations, the government put forward the idea that, and I quote, the victims are at the core of the peace process. In fact, the agreement that marks the beginning of the public phase of the conversations by which the parties adopted in 2012 the negotiating agenda stated, and I quote, restoring the victims is at the center of the accord between the government and the FARC. This idea is not only rhetoric, but has translated into concrete events and proceedings. The first move in that direction was the adoption, before starting with point 5 of the agenda in June 2014, of a declaration of 10 principles, which would serve as a guidance throughout the negotiations on the point. The 10 principles are the following: recognition of the victims, recognition of responsibility, and I quote, the parties would not exchange impunity, satisfaction of the victims' rights. Victims' rights are not negotiable. The negotiation is about how they can be better satisfied. Victims' participation, victims' reparations, guarantees of protection and security, guarantees of non-repetition, reconciliation, and a rights-oriented approach. At the same time, victims' organizations had started to push hard for being formally heard by the two parties at the negotiating table in Havana. Attending the call in July 2014, the delegations agreed on inviting 60 victims to be heard in 5 different special sessions by the negotiating table and on the mechanism to select them. The Office of the UN in Colombia and the National University's Peace Process think tank were put in charge of selecting the 5 delegations that were to participate in the 5 cycles proposed. Each delegation should be comprised of 12 direct victims of the international armed conflict, reflecting the whole universe of human rights violations and IHL infractions. Over a period of several months and in a very solemn atmosphere, all the members of the government and FARC delegations to the peace talks listened to 60 direct victims of guerrillas, state agents, and paramilitary groups, illustrating the full picture of war-related victimization in the country. The visits were widely covered by the press. Constanza Turbay, a businesswoman victim of FARC, commented about her experience. And I quote, "I lost everything, but I am clear that none of this should happen again. So I came to Havana without hatred, with great hope in the peace process. The truth heals us. I came for the truth about everything that was behind the killing of my family. Penalties can be traded, compensation can be negotiated, but you cannot negotiate the truth." Ginette Bedoya, a journalist who survived a sexual assault by counterinsurgent paramilitaries, explained, and I quote, 11 people pour off our pain in Havana on 2nd of November at the negotiating table. We returned to Colombia with a weight less, but with an immense responsibility. The same with the victims of other delegations, not allowing negotiators to rise from the table. Exactly 1 year after the last group of victims visited Havana on the 15th of December 2014, with the shaking of hands between President Santos and FARC Supreme Commander Timo Leon Jimenez, the parties made public the agreement on the creation of an integral system on truth, justice, reparations, and non-repetition. The system is comprised of several judicial and non-judicial mechanisms. The Truth, Coexistence, and Non-Repetition Commission, the special unit for the search of persons deemed as missing in the context of and due to the armed conflict, the Special Jurisdiction for Peace, comprehensive reparations measures for the construction of peace, and guarantees of non-repetition. The Truth Commission, the special unit for the search of the missing, and the comprehensive reparations measures are by definition non-judicial mechanisms. The Special Jurisdiction for Peace is, as its very name indicates, a set of judicial bodies. The expressed objectives of the system are to achieve the greatest possible realization of the victim's rights, to ensure accountability for what happened, to guarantee legal certainty for those who participate in the comprehensive system, and to contribute to the promotion of coexistence, reconciliation, and non-repetition of the conflict. Expressly, the parties adopted for the integral system a gender and differential approach. It should respond to the particular characteristics of victimization in the different territories and with respect to the different groups of people, especially women and children. The Truth Commission. The parties chose as a relatively easy entry point to the negotiation on how to address victims' rights the crafting of a Truth Commission. Point 5 of the agenda expressly included truth as one of its two specific items. The government, in its turn, had passed in 2012 a constitutional amendment stating that a transitional justice package should include a Truth Commission. But very soon it appeared that it was not an easy task at all, because in reality it involved not only a negotiation with the guerrilla delegation in Havana, but also the involvement of the official armed forces as a key actor whose opinion was necessary for the very same viability of the Truth Commission. Finally, in June 2015, the draft agreement on the Truth Commission was made public. The Truth, Coexistence, and Non-Repetition Commission is a highly ambitious Truth Commission. It was designed taking into consideration, on the one hand, comparative experience and best practice of other Truth Commissions around the world, and on the other, the specific Colombian context and challenges. It is composed by 11 commissioners and will operate for 3 years, plus a 6-month period for preparatory work. The 11 commissioners will be appointed by a selection committee of 9. 6 members of the selection committee will be appointed by the government and the FARC by consensus. The other 3 individuals will be the delegates of the respective organizations agreed on by the negotiating table. The selection committee should launch a wide and participatory selection process guaranteeing legitimacy, impartiality, and independence. The selection of the commissioners should observe gender equity, pluralism, interdisciplinarity, and regional representation as guiding criteria. The Truth Commission as the integral system has a strong emphasis on acknowledging beyond knowing the truth, on acknowledging beyond knowing the truth. The promotion of and contribution to acknowledgement is one of the explicit objectives that the parties ascribe the Truth Commission. Acknowledging of victims as citizens whose rights are violated, voluntary acknowledgement of individual and collective responsibility by all who participated in the conflict, and acknowledgement by the entire society of the legacy of human rights violations. Moreover, in the agreement, the national government and the FARC committed themselves to decisively contribute to the truth-seeking process and to acknowledge their respective responsibilities before the Truth Commission. In its turn, the government committed to adopt all necessary measures to guarantee the contribution of other state agencies and third parties to the Truth Commission. In fact, the express mandate of the Commission is not only to elucidate the truth, but also to promote acknowledgement of a series of elements, starting by the incidents and practices that constitute gross human rights violations and grave breaches of international humanitarian law, that took place during the conflict, as well as the complexity of the context and territorial dynamics in which they occurred. The list of elements of the mandate include, among others, collective responsibility of government, FARC, paramilitary groups, as well as responsibility by any other national or international group, organization, or institution. The human and social impact of the conflict on the satisfaction of economic, social, cultural, and environmental rights, the different form in which the conflict affected women, boys, girls, indigenous peoples, African Colombians, LGBTI community, peasant communities, human rights defenders, trade unionists, journalists, cattle owners, business people, the impact of the conflict on the functioning of democracy, including its impact on political parties and social movements, the historical context, origins, multiple causes of the conflict, and the factors that contributed to its persistence, the positive transformation of institutions and organizations and individual and collective resilience, and the strengthening of social tissue. So this is a very wide mandate, point for reflection for those who think that the commission, truth commissions should no go into that direction. The Truth Commission was not envisioned as a group of academics based in the capital city, but as a vibrant and proactive forum for local debate fostering democratic coexistence. In this respect, in addition to the usual investigative functions, the Commission should host public hearings, other cultural ceremonies, and public discussions in which all voices should be heard, primarily that of the victims. Across those different public spaces, those responsible should acknowledge their responsibility and apologize, explaining their acts, committing to non-recurrence, and contributing to reparations and peace building. The Commission should also implement an outreach strategy, including mass media, to inform throughout its operation about the progress made. The Truth Commission was not conceived as a substitute or as a second best option in the absence of criminal justice. The Commission is part of an integral system in which criminal accountability will take place through the Special Jurisdiction for Peace. This is why the Truth Commission has a strong non-judicial character. The Commission was not granted judicial or quasi-judicial powers. In fact, its activities are defined as non-judicial, and they could not implicate the criminal accusation of those who appear before it. The information received or produced by the Commission could not be transferred to judicial authorities with the purpose of attributing judicial responsibility. Neither could they have evidentiary value. The rationale for this clause is to stimulate contribution to truth-seeking and acknowledgement of responsibility. The parties made an effort to provide the Truth Commission with an explicit gender approach. Gender approach is one of the explicit guiding criteria of the Commission. Throughout its mandate functions, the Commission should take into consideration the different experiences, the differentiated impact and particular conditions of the individuals attending to their sex and gender. Special attention should be given to the victimization suffered by women. The agreement includes the creation of a gender working group in charge of specific research, preparation of gender hearings, revision of methodologies, and other technical work in order to make sure that the Commission incorporates a transversal gender approach. So on the special unit for the search of persons deemed as missing in the context of and due to the armed conflict. According to official data, there are in Colombia around 45,000 disappeared persons in the context of the internal armed conflict. In the course of the last 15 years, with the very active involvement of the organizations of the families of the victims and the human rights community, the government has put in place several policies, institutions, and mechanisms to search, localize, identify, and return the remains to the family members. Despite some progress, the challenge to adequately respond to victims' rights is still enormous. Instead of assigning the task of the search for the disappeared to the Truth Commission, as has been the case in other experiences, the parties agreed to the creation of a new special high-level unit for the search not only of the victims of enforced disappearance, but also of those others who for different reasons went missing, including persons who died in the hands of illegal armed organizations, civilians that because of the conflict were separated from their families, and persons who had participated in hostilities and whose whereabouts have not been established. The new special unit will manage, coordinate, and implement the humanitarian action for the search, localization, identification, and returning of the remains to the families. Victims, family members, and human rights organizations were recognized a very active role in the design and operation of the special unit. They will participate in the definition of the priorities for the search and in specific searching, localization, identification, and remains returning processes. As is the case with the Jurists Commission, the special unit has a clear non-judicial character. Explicitly, the parties established that the activities of the special unit could not substitute neither impede the judicial investigation of criminal responsibility associated to the disappearance. With the explicit purpose of stimulating the provision of information to localize the disappeared, it was established that the information received or produced by the unit could not be utilized for attributing criminal responsibility. It would not have evidentiary value, with the exception of the forensic reports and the material elements associated to the bodies. In fact, it is expected that the unit will be able to make substantial progress in the search of the disappeared based on new information provided in voluntary and confidential interviews by those who directly or indirectly participated in hostilities. Making concrete sense of the integral system, the parties provided that the contribution with information to the special unit could be taken into consideration for receiving special criminal justice treatment. I will now explain the agreement on the special jurisdiction for peace, which is the judicial component of the integral system. Understanding that international crimes and certain gross human rights violations could not be amnestied, the parties agreed to the creation of the special jurisdiction for peace. It is a completely new special jurisdiction composed by a tribunal for peace, an investigation and accusation unit, and 3 chambers of justice: the amnesty chamber, the Chamber for Acknowledgement of Truth and Responsibility, and the Chamber for the Definition of the Legal Situation. The express mandate of the jurisdiction includes fighting against impunity, satisfying the victim's right to justice, and responding to the duty of the state to investigate, prosecute, and punish international crimes and gross human rights violations. Equally, the new jurisdiction aims at granting full legal security to those who directly or indirectly participated in the internal armed conflict and committed gross human rights violations of grave breaches of international humanitarian law. The agreement on the special jurisdiction for peace constitutes, in my view, a triumph of the very idea advanced in international human rights law that individual criminal responsibility for international crimes and gross human rights violations needs to be attributed by a court of law, even in the context of a political negotiation on the end of a civil war. The Colombian experience demonstrates that under certain conditions, and this is very important, under certain conditions, even a Marxist insurgency can agree to the creation of a domestic criminal justice arrangement within a transitional justice context. Of course, the arrangement emerging from that political negotiation has particular features, but maintains the essence of criminal justice. I will discuss the nature, structure, and procedures of the special jurisdiction for peace, identifying the key elements that, in my view, were the conditions of possibility of the agreement. As I will show, the following elements are associated to making accountability, criminal accountability, and political honor compatible. So these 6 key elements are the following: the granting of amnesty for political crimes, which included restoring the Colombian tradition of amnesty, on amnesty, including amnesty for killing in combat and apprehending enemy combatants, the creation of an entirely new special jurisdiction with a tribunal for peace not subjected to the ordinary hierarchy of courts in Colombia, new judges elected by a special panel appointed by the negotiating table, jurisdiction not only over guerrillas, but also over state agents and civilians who collaborated with counterinsurgent paramilitary groups, collective acknowledgement as the entry point to the jurisdiction, no trial, strong restorative dimension of sanctions for those who acknowledge truth and responsibility. So those are my 6 elements which, in my view, are the conditions of possibility for an arrangement including criminal justice accountability negotiated within the peace negotiations that made the agreement possible. First, the agreement on the special jurisdiction for peace could have not seen the light if it were not for the crafting of a strong component of amnesty for political crimes and those connected to them. As the Belfast guidelines indicate, and I really strong here recommend those of you who haven't gone through the Belfast guidelines on amnesties, because I think we're the most useful tool we encountered being part of the legal team to the negotiating table discussing amnesties. So as the Belfast guidelines indicate, in my view, the Colombian case shows that amnesties could well be understood as part and parcel of broader accountability processes. In the Colombian case, is a key component of a broader criminal accountability scheme. In fact, from my perspective, the Colombian experience makes a strong case for the understanding of amnesties as a clear transitional justice mechanism. I consider that seriously unfolding the possibilities of amnesties within the field of transitional justice will contribute to increase the chances of criminal accountability for international crimes within peace negotiations. In the context of political negotiation of the termination of an internal armed conflict, amnesties for political crimes carry a very important meaning of political honor. In these types of contexts, amnesty allows for the understanding of the insurgent as a political actor rather than as a pure terrorist or war criminal. It is only based on the recognized political agency that insurgents can move forward towards acknowledgement and accountability. Citing Article 6.5 of Protocol 2 to the Geneva Conventions, the agreement provides for the broadest possible amnesty for the rebels who belong to organizations that signed a final peace agreement. With respect to the crimes that are susceptible of amnesty, the agreement combines an approach based on non-exhaustive list of the specific crimes and 3 guiding criteria. The list includes the crimes of rebellion, sedition, conspiracy, illegal bearing of weapons, the killing in combat compatible with IHL, and the apprehension of combatants conducted in military operations. The understanding of these last 2 crimes, killing in combat and apprehending of combatants conducted in military operations, as political and susceptible of amnesty is of particular importance in terms of the recognition of political honor to the FARC. In spite of not being necessarily war crimes domestically, the 2 conducts had been excluded by the Constitutional Court of Pardons and Amnesties, assimilating them to ordinary homicides and kidnappings. So rephrasing them into the IHL discourse and set of norms helped us to include them as crimes susceptible of amnesty, and then discuss the broader arrangement for criminal accountability. The agreement established that the following crimes and conducts are connected to political crimes, and in this regard should be amnestied. Those crimes specifically related to the rebellion committed with the occasion of the conflict, the crimes committed against the state and the constitutional regime, and the conducts directed to facilitate, support, finance, or hide the development of rebellion. On the other hand, the agreement makes clear that there are a series of crimes that could not be amnestied, including international crimes as defined by the Rome Statute of the International Criminal Court. In a specific clause, the agreement states that the following crimes could not be amnestied: genocide, crimes against humanity, grave war crimes, the taking of hostages and other grave deprivation of liberty, torture, extrajudicial executions, enforced disappearance, rape and other forms of sexual violence, forced displacement, and forced recruitment as established in the Rome Statute. This clause was welcomed by key actors in the international community, including the Office of the Prosecutor of the ICC, in a public press release. The question then was what to do with investigations conducted and sentences imposed in absentia for crimes that could amount to international crimes and gross human rights violations. There was a strong preoccupation among FARC leaders as well as among government delegates about sustainable legal security. Legal teams on both sides coincided on that what could grant the most legal security would be conducting serious and legitimate investigations and prosecutions domestically in order for the material res judicata to operate. In a recent interview for a Colombian news magazine, Enrique Santiago, the Spanish lawyer and Izquierda Unida activist, this is the Socialist Party in Spain, who acted as the main FARC legal advisor, explained that he encouraged the FARC to obtain legal security through domestic legal institutions. Going the way of a general amnesty would have meant spending the rest of their lives defending themselves before all kinds of tribunals, he explained. But a prerequisite for the FARC to accept the creation of a special jurisdiction to deal with international crimes and gross human rights violations involving them was that the special jurisdiction should also address the responsibility of state agents and civilians who supported counterinsurgent paramilitary groups. In July 2015, Enrique Santiago explained to the Colombian news magazine Semana that the FARC was not going to accept the creation of a tribunal to put exclusively the guerrillas on trial. And I quote, "That is not an alternative because they are not defeated. This is not about rendition," he stated. On the alleged intention to seek perfect symmetry between the legal treatment to the FARC and to the state agents, Santiago asserted that if the most responsible among the guerrillas are to go into prison, those most responsible among state agents should go as well. He concluded that the FARC was looking for more equity and balance in the resolution of the conflict. And at the same time, it started to become clear that the great majority of the defense sector wanted a transitional justice arrangement to cover the members of the armed forces and the police. Unlike what happened with previous amnesties for guerrillas and special criminal justice arrangement for counterinsurgent paramilitary groups, this time influential voices within the official armed forces wanted their men to benefit from transitional justice. It became usual to hear among high-ranking officials that this time they would not allow that their men end up serving 30 years in jail while guerrilla commanders become senators and governors. Moreover, it was not uncommon to hear among high-ranking military personnel, "Whatever criminal justice benefit you give to the guerrillas, our men should receive it too." Since the beginning of the negotiations, the government had envisioned a special criminal accountability arrangement covering guerrilla ex-combatants as well as state agents, as was adopted in 2012 to the constitutional amendment called the Legal Framework for Peace. In that respect, it was not that difficult to reach a consensus on the personal jurisdiction of the personal jurisdiction, of the Special Jurisdiction for Peace. extending the personal jurisdiction of the Special Jurisdiction for Peace to civilians who have aided or abetted the illegal armed groups, especially to those who have financed or collaborated with the paramilitary groups, the counterinsurgent paramilitary groups, was another condition of possibility of the agreement. In the view of the FARC, if there was going to exist criminal accountability for the guerrillas, not only state agents would have to subject themselves to the new special jurisdictions, but civilians who committed gross crimes through instigating, aiding, abetting, and collaborating in various forms with counterinsurgent paramilitary groups. In the same interview to the Semana News magazine in July 2015, Enrique Santiago claimed that the greatest impunity niches in Colombia are related, on the one hand, to those who instigated paramilitary groups, and on the other, to the political groups behind the crimes of state agents. The agreement includes then a wide clause on personal jurisdiction, establishing that those who, notwithstanding not being part of the armed groups, have contributed directly or indirectly to the commission of crimes in the context of the conflict. Especially, the agreement makes specific reference to the voluntarily financing and collaborating with paramilitary groups as conducts falling under the new jurisdiction. However, the tribunal can only compulsory call to appear before the jurisdiction those persons who had a determinant participation in the crimes subjected to the new jurisdiction. A key element that made the agreement on judicial accountability possible was to create an entirely new special jurisdiction, composed by entirely new institutions, which, despite being part of the judicial branch of government, are not subjected to the hierarchy of ordinary courts. In this manner, the FARC can say that it is not subjecting itself to the rule of the state against which it fought for 50 years, but that it is voluntarily subjecting itself to a special justice created by the will of the organization. In fact, the special jurisdiction will hear on an exclusive and excluding basis over the matters related to the internal armed conflict. The decisions of the Tribunal for Peace are final and are not subjected to appeal or to any form of revision by the ordinary Supreme Court of Justice. The Special Jurisdiction for Peace will have 42 new judges. The great majority of them will be Colombian, and only around 4 or a bit more will be international. The judges of the tribunal will have to meet the same requisites as the judges of the Supreme Court of Justice. The parties will define by consensus before signing the final agreement the selection mechanism and the criteria. As we speak, the parties are discussing the integration of a selection panel, which will launch a participatory process for the appointment of the new judges. The parties specifically established that the Special Jurisdiction for Peace will be integrated, taking into consideration gender equity and respect for the cultural and ethnic diversity of the country. A third, or I think I am, this is not the correct number, but a third key element that made the agreement possible was to establish truth and acknowledgement as the very entry point to the special jurisdiction. Those who tell the full truth and acknowledge responsibility before the acknowledgement chamber will receive a special sanction of effective restriction of liberty with a restorative component from 5 to 8 years. The acknowledgement of responsibility can be done collectively and in a written form. The chamber can decide when the acknowledgement of responsibility has to be done in a public hearing. The basic formula, in a certain way, resembles the Amnesty for Truth formula of the South African Truth and Reconciliation Commission. In the Colombian case, however, acknowledgement will be done before a judicial forum and will be followed not by amnesty but by special sanction. The strongest incentive for telling the truth and acknowledging responsibility lies, on the one hand, on the thousands of investigations and sentences issued in absentia by ordinary Colombian prosecutors and judges over the last decades. On the other hand, it lies on the not less important research and reports by the human rights organizations. The operation of the Acknowledgement Chamber is based on both the Office of the Prosecutor General, the administration of the ordinary judiciary, and other relevant public agencies should hand over to the Chamber their respective reports identifying all investigations, processes, and sentences related to conducts committed with the occasion of the internal armed conflict. The report should group the cases by the allegedly responsible and categories of conduct. The victims and human rights organizations can also submit reports to the Acknowledgement Chamber, identifying those presumably responsible and grouping cases by similar categories. The Chamber should contrast all information available and, based on it, examine the completeness of the truth and acknowledgement. When there is truth and acknowledgement of responsibility, the procedure is quite special. It does not involve an indictment, charges, or accusation, neither trial. Instead, the Acknowledgement Chamber issues a concluding resolution in which it identifies the individual responsible, the specific conduct, and its legal relevance. The concluding resolution is sent to the Tribunal for Peace for the imposition of the sentence. When there is no or incomplete truth nor acknowledgement of responsibility, the Chamber should send the case to the Investigation and Accusation Unit, which in practice works as the special prosecutor of the Special Jurisdiction for Peace. Strictly guaranteeing the process, the unit will make the definition whether it should open an investigation and prosecute those responsible to bring them before the Special Tribunal for Peace. If the person is found guilty, she will receive an ordinary imprisonment sentence from 15 to 20 years. The strong restorative dimensions of sanctions for those who tell the truth and acknowledge responsibility constitutes a key condition of possibility of the agreement. Those who tell the full truth and acknowledge responsibility are entitled to a special sanction that has two components. On the one hand, the effective restriction of rights and liberties, including free movement and the right to define residence. In no case, effective restriction of liberty, however, should be understood as jail or prison. The parties will agree on a special national or international monitoring mechanism that will supervise the execution of the sanction. On the other hand, the special sanction includes a restorative justice dimension. Those who acknowledge can propose to the respective chamber a detailed individual or collective restorative project, identifying specific tasks and activities, their phases, timetables, and places for execution and residence. According to the agreement, the projects can include, among many other activities, construction or reconstruction of infrastructure, substitution of illegal crops, environmental recovery, and demining. The restorative project should be consulted with the communities in which it is supposed to be conducted. Once the chamber approves the project, includes it into the concluding resolution. And the Tribunal for Peace will make the final definition on the sanction and the place where the person will reside. To date, the nature and characteristics of the special sanctions for those who acknowledge responsibility are a source of intense discussion among different actors in Colombian politics. The opposition party considers that those sanctions amount to impunity for FARC members responsible for international crimes. They argue that they should receive ordinary imprisonment for 5 to 8 years, as was the case with the counterinsurgent paramilitary groups that demobilized from 2003 to 2006. We claim that it is completely according to international law in the context of finalizing a 5-decade internal armed conflict. Comprehensive reparations measures for the construction of peace. And I will go through this very quickly. I don't know how are we doing in terms of
10 more minutes.
Yeah, okay. So I will go quickly on reparations. The agreement on the integral system on truth, justice, reparations, and non-repetition includes a specific chapter on reparations. The chapter is somewhat different from the other ones because the reparations component of the system rests on the already existing comprehensive administrative reparations program and its institutions and mechanisms under the law on victims' rights and land restitution. And at the same time, the agreement addresses the limitations and difficulties that the program has had in its implementation. We think that the end of the conflict represents a unique opportunity to strengthen the program being implemented by the government. So I will just quickly list the elements that were added in the agreement. So the parties agreed to 7 new reparations measures in order to strengthen the already existing administrative program. Acts of early recognition of collective responsibility, concrete actions to contribute to reparations by those who have caused damage, strengthening the processes of collective reparations and their coordination with development programs, expanding and strengthening the strategies of psychosocial rehabilitation at the individual and community levels, implementing collective processes for the return to villages of displaced persons and strengthening the reparations of victims abroad, strengthening the process of land restitution, and adapting and strengthening participatory policies regarding attention to and comprehensive reparations for victims. I want now to identify 5 other key factors that, in my point of view, from my perspective, were also contextual variables that make this agreement possible. In the previous section, I identified the key elements that constitute conditions of possibility of the agreement on the special jurisdiction for peace. In other words, which were the specific arrangements and, in a way, compromises in the design and definition of the special jurisdiction for peace that made the agreement possible. And now I want to explore, I have this less organized and clear than the previous section, but I really want to explore this more contextual variables that, from my perspective, were also definitive or contributed in a certain way for the crafting of the agreement. So you can think of these 5 points as working hypotheses, or at least variables that need to be, researched further, and really with further research we can establish which is the exact specific weight of each of the variables for contributing to the making of the agreement. So this was a peace negotiation by a democratic government with a 21st century agenda on human rights, seriously committed to accountability, plus our domestic precedent, which is 10 years of implementing special peace and justice criminal proceedings within a transitional justice framework, responding to the political negotiation with the counterinsurgent paramilitary federation. So I'm not going to go over that. I wrote a piece actually in a book edited by Lorna and Kieran McAvoy on the peace and justice arrangement for the counterinsurgent paramilitary groups, which was adopted in Congress 10 years ago. But anyways, my point is that we were able to conceive of the integral system on truth, justice, reparations, and non-repetition, this time within the peace process, only building upon our own experience of 10 years of implementing, of designing, implementing, thinking on the results, implications, consequences of those previous peace and justice criminal procedures. My second point is that, and this is a bit tricky, and I hope I really got the English correct, but I think that the FARC understanding of the grassroots and the human rights community as one of its main pretended, alleged, addressed constituencies is a key element, because they could not afford to go against decades of demands for judicial accountability by the human rights community. And linked with that, in this sense, FARC could not allow for impunity of state agents, which has been at the core of the human rights movement for decades in Colombia, as is, of course, the case throughout Latin America. So including state agents into the transitional justice equation contributed to the crafting of an arrangement meeting, in my view, international standards. And fourth, the role of international community. And I call this is my working title, Law in Action. And I want to give a concrete example, which I think is very important, which is the putting together of a group of experts by the Norwegian government, which was the guarantor to the Colombian peace process. So they decided that the FARC, mostly, but the government as well, needed to be exposed to international expertise, to international standards, to the contents of specific decisions by the different bodies. And they put together this group, which met over 20 times for many months, even more than a year. And part of that group were the two main legal advisors to the FARC. So they had a very high-level forum to expose their ideas and to be challenged as well by international experts, really very high-level people, who helped in crafting interesting avenues for, finding finally a formula on how to balance and how to, deal with the justice versus peace dilemma, which is very real. It's not a myth, it is very real. And part of that is the role of the ICC and the Office of the Prosecutor of the ICC. I really think, and I experience it myself, that the ICC operated in practice on the ground as a phantom that was present all the time throughout discussions between the parties, within each delegation, and in the various fora that addressed the question, not only over the years of the peace negotiations, but during many years before. So I really think, and I meant to finish some years ago a paper on positive complementarity on the case of Colombia, but having experienced the peace negotiation and on point 5 on the agenda, victims, I think that my intuition then was correct, and it was that positive complementarity really operated on the ground, using the ICC as this phantom being present, and in a certain way manipulating the law, the making claims that are not really definitive, law in terms of even decisions by the very, ICC, but only views and interpretations, partial interpretations by the Office of the Prosecutor. But anyways, it played this role. People started to include arguments on whether this is, this will comply with ICC standards or not. So I think I will conclude there to open more space for discussion, and I will just conclude with a very simple reflection, which is that the Colombian experience is showing, in my view, that it is actually possible to negotiate with an insurgency in the framework of a peace negotiation, the creation of a special domestic criminal accountability arrangement for international crimes and gross human rights violations. But as I showed, that was only possible by including a series of special devices associated to the making of criminal accountability and political honor compatible. The transitional justice field will have to assimilate what emerged from the Colombian case in order to build a much more nuanced account on how to make those responsible criminally accountable for international crimes and gross human rights violations, and at the same time make peace. Our experience can also nourish the specific contents of the duty of the state to investigate, prosecute, and punish in the context of a negotiated political transition. Finally, in incorporating the Colombian case, the transitional justice field should take into consideration the key contextual variables that played a role in the making of the agreement.
So now, thank you so much, Cata, for that very interesting lecture. Now, Camila Sanchez, as I said, works for the Justicia, but he's also professor at National University and has been also a key person working behind the theater on these issues.
Thank you. I would like to start by thanking the Essex Transitional Justice Network, Clara and Sabine, for giving me the opportunity to trash the Colombian government and especially Catalina on these issues. Now, only 10 minutes, so I'm going to focus on 4 points based on what Catalina just mentioned. And my first point is the reference about setting example or being example to the world. That is something that gets always play, and it scares me a lot. I think it puts a lot of pressure. I don't know if you've seen that movie Whiplash. You know, that movie that everybody loved. I don't know why. For me, it was the story of an old man harassing a young kid, but still made it to the awards. But I think that sometimes we feel like the little guy there, the adolescent that was harassed all the time, because we are on this pressure to be the example for the world. That this is, you know, dividing waters, and no one has thought of this before, no one has done it, and after this, everyone will have to do it like this. And I'm really against that idea. I know the pressure, I know why a lot seems to be at stake here, but I think that puts, as I said, a lot of pressure on the people that are negotiating to do it right, you know, because it's gonna be set on stone for the eternity and for the old world to then follow. For the idea of how to understand the legal precedent and the standards, and also the pressure of peers, the peer pressure and other experiences to follow what Colombia leads, you know. And we came from Sri Lanka, and we were invited there because everyone said, you have to invite Colombians, you know, because the next best thing, and I think that's something to be very mindful of it. So I think it's finding a balance. It is not preventing, I don't think you are preventing the end of the world as we know it. But I think you have something on your shoulders. You have the responsibility, or we have the responsibility of ending a long conflict and to responding to the needs of more than 6 million people. And we know, and we embrace the challenge. But I think it's completely mistaken making it as the example for the world. So that's what I like Catalina's idea of, you know, the preconditions or the things that made the agreement possible, and what cannot be just only translated, you know, to Senegalese and be used in Sri Lanka or anywhere else. So I think, and I understand the need to be pride and to sell it and to show that we can do it, you know. But I think one thing is to show that we can do it, and the other, and a very different thing is being Cristiano Ronaldo. You know, so there is a balance needs to be struck down in the middle. Second, the idea of it is not the perfect formula. So what it is, you know, finding this balance between peace and justice is very difficult. So there is nothing perfect, but we can have a lot of imperfection, you know, and it is not white or black. So what I think is this is a workable system or a workable formula for the Colombian needs and for Colombia's concerns. And my call here is simplicity. You have heard Catalina and all the details, because we are really good and fanatic of the details. You know, so there's this chamber and this chamber and this chamber and this chamber, boom, Truth Commission. You know? So for now, what I think for implementation is really clue to think about something that makes it work. It is already complicated as it is. And I think we have to be very mindful of that when implementing. And there I was just to focus on two things. Human Rights Watch has been very vocal at I would say they've been very effective at saying that the agreement as it is not complying with international standards. And mainly because two things. One international argument, that is the idea that it is not severe enough when it comes to punishment, for two ideas. First, that because it does not entail jail time, and second, because it's a la carte punishment, because the decision can be, you know, negotiated with either the insurgents of the state actors involved. And I think that is just an interpretation of law. I wouldn't say that this is set in stone and that we cannot have an argument or a discussion with that. And I think that what I wanted to do is to invite you to go further on this discussion. I think it's a lot to be said there, so it is not as it is presented usually, you know, on the headlines of the newspaper that Human Rights Watch says it is against international law. So everyone just buys that. And the other thing is about the constitutional law. I cannot even start to tell you how happy we are when an international outsider lawyer tells us that he interprets better our own constitution that we can do. That's what Jose Miguel Bianco actually did. He said, that agreement of yours even violates your constitution. After all that jurist involvement, and I think he's completely wrong, and factually wrong here, because he says that it is even softer than it was with the paramilitary, because the negotiation with the paramilitary groups involved for them to accept jail time. And that's factually wrong because they didn't accept that. They first put arms away, and then they were compelled to do it. You know, that they say, okay, I take my arm and I go to jail. That didn't happen. So I think he's got his history wrong there. And three, then if it is not perfect and it could be workable, where are the red flags, the red lights, what cannot be crossed? I think that's the main clue here, and I think that it will involve a lot of monitor and a lot of crafting during implementation. I think it is not a final document, it's got living content, because it will depend on how certain features get interpreted or get implemented, that we will see, for example, if the idea of punishment, it is severe as to be considered punishment or not, if the idea of defending that the criminal responsibility should be focused on the most responsible is, you know, sustainable, or there is just few of them that are not representative of what happened, that it just get, you know, left them off the hook. And third, that is very difficult to find a balance, is that if it allows for proper victims' participation, if the system allows for proper victims' participation. And what are the maximums, what are the minimums, minimal standards, because, you know, Catalina kept saying, you know, full truth. What does full truth mean? You know, and all that are standards that we need to understand, to deal with, to interpret, and to then implement. And my final point, and given that this is an academic setting and you are interested in keep on studying this issue, and some of you are actually trying to look for issues to write PhD and LLM theses and dissertations, I think there are at least 5 interesting issues to keep on the loop for the next years, for the years to come, that to me show how international law can shape a peace process, but also how that process can shape international law back. And I think at least 5 issues are of interest, or to me are very interesting. I don't know what you people do, but first is that idea of lex pacificatoria, as Christine Bell points out, the idea of what is the legal nature of the status of one of these agreements under international law. Is there such a thing as can be thought as treaties or not? You know, there is this idea of belligerency, that is to believe that an insurgent group is set as an international subject for the idea of making war. So we are defending now the pacific agency, or I don't know how to put it, peace belligerency, something like that. There is the idea, why not then give international status for an insurgent group to make peace? So there is this discussion about the scope of special agreements under international humanitarian law that are meant to be agreements for war, and now we're using that as an agreement for peace. And it's very controversial, but I think that's one of the features that it's interesting to be studied further on. Second, about the idea of the involvement of the Security Council and the role of the international missions. You know, we have now one of these, a call for a monitoring body that will monitor, for example, the commissioning of weapons, but it cannot be composed by militaries. And that's very puzzling, you know, because who knows about weapons? Those who use weapons. You know, it cannot be just a civilian thing, or at least I cannot be invited. I know nothing about weapons, and I think that the majority of people who live outside the United States. But that's another different issue. Third and fourth, the most common issues is international human rights law, and specifically in the context of the Inter-American System for Human Rights. There were very strict standards when it comes to amnesties, victims' rights, the idea of punishment and stuff, and the idea of positive complementarity that Catalina talked about. I think that's a very exciting development, at least for research. And the final one is international cooperation, and how to see it as a legal obligation and not charity. And the role of all of these, you know, international actors that come for the signing of the agreement, you know, to take the picture and to are your friends there, but then they just run away to find the new, you know, the new fashion. So how to make it different this time? And I think all of those 5 issues will be very interesting in order to see and to understand better that weird animal that we now call transitional justice. Thank you very much.
Well, thank you so much to Catalina and Camilo. I'm so grateful, well, first of all, for your very interesting and enlightening presentations, but also I'm so glad to have you here, because obviously we have been working together for quite some time, and I'm really, as Camilo has just said, they came from Sri Lanka, and Camilo decided the best way to London from Sri Lanka was via Washington, so they really made a lot of effort to come here, so I'm very grateful to them. And I also am particularly grateful, having started to work a little bit on Colombia also for the last few months. I'm particularly grateful for your very positive outlook on what's happening in Colombia, because I have to say, and I obviously I'm just an outsider, but I have to say, for me, very often I look at what's going on and everything that's ahead of you, and I think it's just intimidating, all the work that still has to be done. So that you have such a positive outlook, I think is absolutely brilliant. Before I open this up, so the idea is we have about 45 minutes, I think, for questions, and the idea is really to take about 5 questions and then at a time, and then Catalina and potentially also Camilo will try to answer them. I have lots, but I'll try to let you get in first, and if you don't have questions, then I'm happy to have my own. But what I just wanted to say, because a really important point to my own heart is, of course, the involvement of civilians, and in particular corporate actors in transitional justice. And so I just wanted to use, because Catalina mentioned this point, I just wanted to use it as publicity for our event tomorrow. We have an event tomorrow from 10 to 12, a panel discussion with Catalina, with Camilo, with Clara, with Charles, and with Sheldon over there, to talk specifically about the issue of corporate involvement in transitional justice, how to do it, what the challenges are, etc., with a focus on Colombia, but also beyond Colombia. But with all of this, now I'll open up the floor for discussion. So if there are any questions and comments, and please keep them brief. And I've just been to Colombia, and they were longer than the presentations, and please don't do that, sorry to say. So do we have microphones for this, or how do we? No?
Maybe the person that stands up.
Okay, so does anybody have a pressing question? Otherwise, as I threatened, I will. Mandira.
First of all, thank you very much for Camilo and Catalina. It's very illuminating to really hear what you have said, how you are trying to balance peace and justice in Colombia. Certainly, it will inspire many countries in future. There was time when everyone used to look at South Africa. Now everyone looks at Colombia. I come from Nepal, where we are also debating some of these issues, and I have to confess that we are not very close to what you have been just presented. You know, in terms of thinking, in terms of a lot of this discourse that is needed for this process to happen is very important. One of my questions to Catalina is, as you have presented this as an integral system through justice, reparation, guarantee of non-recurrence. But at the same time, you have also highlighted that, for example, the statements or the information provided to the truth commissions are not admissible in judicial process. If it is integral, how do you interwoven, the work of different components of the transitional justice? This is one of the questions. The other question is that you also mentioned about the special jurisdiction. I can understand the political meaning of it, especially for those guerrillas who have been fighting for 5 decades, for example. But at the same time, in the context like this, where inequality is one of the root causes of the conflict, right? Those who are in power, those who are special, really get special treatment. So by having this sort of mechanisms in place, having special treatment of the judicial process for people in power who could actually negotiate this space, do you fear for reinforcing the same kind of unequal kind of structures into the new kind of transition? These are 2 questions.
Okay, Borislav.
I have also 2 questions. One is more theoretical and the other is more practical. I'm Borislav Tronov. I work with Open Site Foundations, and I run a grant-making program on transitional justice. So before the theory about what works, I think had 4 elements for accountability to work: activist judiciary, civil society, including victims, international pressure, and the 4th was the removal of spoilers. And you didn't say anything about the removal or the self-withdrawal of spoilers. Can you comment a bit whether we need to dispense with that ingredient of successful transitional process, or is there something very specific about Colombia? I mean, Sri Lanka is a shining example of how the removal of the key spoilers suddenly kind of opened the floodgate. And my second question is the road to the paradise of transitional justice sometimes hits the hell of budgets of money. So who's going to pay for all this? And how is that planned?
Okay, given that was already 4 questions, maybe one more. You had a question, right? And then Catalina has a chance to answer, and maybe you too, if you want to comment.
I undertook the LLM in 2007, and I'm a consultant on human rights and development. Thank you, Catalina, for your presentation.
Could you speak a little louder?
I understand that I can see, of course.
Can you speak a little bit up? It's difficult to hear you.
Maybe people can stand up if you don't mind, because the voice is lost. Because of the chairs, I don't know. The room.
Or my devices are there. Okay, I understand that, and I can see that the negotiation process has gained a lot of attention and support internationally, but that's not necessarily the case within the country, or at least that's my feeling. Aside from the opposition from the political position, why do you think this is? And bearing in mind that it's of course crucial for this process to work, to count with the support of Colombians, what do you think could be done to change this situation? Thank you.
Okay, do you want to? We just have to, this is not the best room for this. I apologize. We have to kind of swap places all the time.
Thank you for the questions. I think they are very, key to the point. Comes from a, high level, well-informed audience working on these issues. And you were pointing to one of the, critical elements on designing this integral, coherent system. No? And when I explain this, people ask that question. So it is meant to be a system, not the sum, only the sum of the different institutions. So why is it a system? And what does it make different to be a system? So actually, we worked a lot on the concept of conditionality. Make every criminal justice benefit conditional upon the contribution to the truth-seeking and the contribution to reparations by the person who is going to receive that very special form of sanction, that very special, an amnesty, or a different form of resolving his or her legal situation. And actually, I have to tell that at the end in the agreement, there are not like a specific, formulas to make that conditionality, happening in actual procedural terms as we wanted to. So now what we have ahead, this is a challenge ahead, is to, put into much more concrete procedural terms and, bring this to earth, what conditionality means in concrete, specific procedural terms. So, for example, the idea, and we are working on this for the implementing legislation, and we have to, the agreement provides for an amnesty law to be passed. So the idea, and I'm, a strong supporter of this, is that people who received amnesty don't need to go, all of them, before the Truth Commission, because this is, a group of thousands of people who will get an amnesty, and then if we make it conditional upon going before to the Commission, it will take, first of all, it will take forever, so the definition of their legal situation will take forever, and that will affect the DDR process. We learned actually from the South African experience in the way that, what was the amount of time that the previous, full truth exercise before the Amnesty Commission or Amnesty Committee of the Truth Commission took. And so we decided not to make it conditional, the amnesty, upon coming before the Truth Commission, but the idea is that the Truth Commission can call whoever the Commission wants, and the person will have to go before the Commission, otherwise the person will lose the benefit. That's kind of the basic, conditionality formula mechanism that will unite, the different pieces of the agreement. The same, and I think this will be crucial for the unit, the special unit for the search of the missing. And in the chapter, and I mention it here, in the chapter of the unit, we actually were able to include a very specific clause saying exactly that people will, or the jurisdiction will take into account for granting special criminal justice treatment the contribution to the unit. But it's not, because this system is not thought of as, the Truth Commission nor the special unit as second bests for criminal justice, as was the case with other Truth Commissions, South American Truth Commissions, the early ones. this is not the case of a second best option in the absence of political conditions for criminal justice. So the idea is to provide very strong incentives for people who have participated in serious things to go before the Truth Commission and before the special unit. That's the basic idea. So on your second point on the root causes of the conflict and how, as if I understood you well, how these very special sanctions will not instigate new forms of violence. It was inequality.
The sense of inequality among them.
I'm now convinced that the justice component of the transition is just that, a modest component. I should probably have added a little bit on that. This is a component of a much broader, complex, very ambitious project, gigantic project on social and political transformation, which is the peace agreement in itself, which has different components, one on land restitution. So that's a huge challenge in itself. Another one on political participation, the other one on dealing with the issue of illegal drugs. So those components of the peace agreements will be the ones, pioneering the transformation of, power imbalances in the different regions, in the different, fields, as if I am, making myself clear. And the justice component will probably add, and this has to do, and I think we can discuss that more tomorrow in the panel, probably through opening the jurisdiction for civilians who have, for example, financed counterinsurgent paramilitary groups. There is a space to discuss the more socioeconomic dimensions of the conflict within the jurisdiction. But my point is that we shouldn't really think of the transitional justice mechanisms, the ones replacing the more transformative agenda in terms of social policy and the development policies that have to be in place, and transitional justice is not a substitute for that agenda. So on the spoilers, I don't know if I got it correct. From my experience, and I don't know if, there are many Colombians here actually who could comment on this. This is all about, who is in power and the different political parties playing different roles. Of course, being able to finalize the war has been on our political agenda for decades, for 30 years. And, the previous government pioneered the idea that we actually could, gain the war through military means. So they are now, of course, very frustrated that we are about to finalize the peace agreement, because they think that we compromise too much, not only on justice, but of course on land restitution, on political participation, on democratization on the territories. Some of them want to keep certain critical features of the status quo on distribution of the benefits of development. So my impression is that we will need to find a way to coexist, to coexist and to be able to advance our causes and our different visions of the polity and our different visions of what is the best for the country in a democratic way, in a peaceful democratic way, everybody being able to actively participate, run for, for elections, and not, of course, not appealing to violence. But I don't know. We will have to, have them, the ones who are now very strongly opposing the peace agreement. We will have to take them seriously and involve them in a democratic, peaceful, discussion, public discussion. That's my take on it. Might be very controversial and debated. Who is going to pay? That is a crucial question. Actually, many people have told me, this is too ambitious. It's too much. You Colombians, you wanted the best truth commission in the world. You wanted, the jurisdiction, having personal jurisdiction over these 3 different groups. You want this entire thing about restorative justice. Too much. No way. So we are conscious that this is a gigantic project. We are conscious that it is very ambitious. And I think we now have 10 years of experience in implementing transitional justice after the passing of law 975 on peace and justice. So we now can make claims which were impossible 10 years before on, for example, prosecuting small number of people who are the most responsible. Those claims were in our legal tradition, in a continental tradition, they were impossible 10 years ago. So now we can be much more practical, much more pragmatic, but we learned as well the limitations of just having one mechanism. We learned how limited it was to think that criminal justice could do everything in terms of satisfying of victims' rights. So that is why we are, trying, or we designed the system to have the different mechanisms. Our budget in government should support part of this, but of course we are expecting to have the international community on board. We already have done, actually very good arrangements with the European Union, with the US, and they are willing to contribute. And we have all of us, and I think that was a very good point by Camilo. All of the, European governments who, and I really like your point, pushed hard for this to happen, no? Press us so hard. No, amnesties are not possible anymore, so you need to, and we made it. So this is a very Colombian saying, I don't know how to say it in English, but I will say it in Spanish. Ya que matamos el tigre, no nos vamos a asustar con el cuero. The one who gets that in English. No, it's basically somebody, how, yeah, does that exist in English? No. Basically the idea is that
you cannot be scared of the skin.
Once you kill the tiger, you cannot be really frightened by the skin. So we killed the tiger. Everybody pushed us very hard, including the Office of the Prosecutor of the ICC, including the Inter-American Commission, including our, dear partner governments. Everybody said, you have to do it. It's possible. The transitional justice field, it's about this, building a workable formula on peace and justice is possible. And we made it. And now we cannot say, oh no, that is too difficult. It's too ambitious. We will need to find a workable, doable way. And of course, we now know that this needs to be designed into phases, different phases. We have to prioritize. We have to be very, the selecting, the who's gonna be in the tribunal, it's crucial. But at the same time, and that I will really want to stress my final working hypothesis, this was possible because we have a sophisticated, vibrant legal community. I mean, many people, you know, in this room who have been, you know, Clara herself, I mean, done their PhDs here, being exposed to all this. I'm campaigning for the repatriation of all my friends and colleagues who are teaching in very prestigious universities throughout the world, just as this. This is the time to come back. This is the time to, you know, be a judge for the Peace Tribunal for Peace. So I think it's doable. It's doable with the cooperation of the international community. It's doable in phases. It's doable over a 20-year period. I mean, I know, say to, you know, everybody, this is the Tribunal for Peace is at least 15-year project, at least.
Can I just
yeah.
throw something else? What
Yeah.
I meant actually is whether there is a way to make those that have made super profits pay, rather than rely on our taxes in the European Union, or
Oh.
institutions, the ICC, which is in deep financial trouble,
Come tomorrow.
the system, which is bankrupt.
We resolve all of that tomorrow.
No, that's
Is there something kind of more than just relying on the usual development partners, European Union governments, the US?
yeah.
Something innovative in that aspect
Mhm.
as well as in all other aspects.
Something innovative. I mean, anyways, on the point with regard to the eventual potential, you know, contribution by those who benefited. I mean, this is interesting that the agreement provides expressly space for discussing accountability of third-party actors. Within the Truth Commission, within the special jurisdiction, how will that translate into concrete contribution in terms of money, assets to the reparations fund is still a question on which my dear friends Clara and Sabina are working on to advise the government on how to do that. But it's a big challenge. I mean, how to, for example, how to translate individual criminal responsibility found or established by the Tribunal for Peace into, you know, a large sum of money coming to the reparations fund. That's not yet, you know, decided or designed. So we will need to work on that. You're right. And Veronica's, of course, you know very well the you know, the political scene in the country. There's a huge debate, and interestingly, the issue on impunity plays a huge role in the debate. I mean, Uribe's, for those of you who remember, the former president who, you know, installed re-election and wanted even to run for a third period, and after all, the Constitutional Court said, no, that's against the essence of the Constitution, and he couldn't. And the one that believed that the best way of ending our civil war was to win militarily. They now are, an established party in Congress, and they openly claim, which is very effective, no? I mean, this is impunity for crimes against humanity. And it's effective because they say, this is not going into prison. This is just this very wishy-washy restorative justice thing. It's not prison for people who committed crimes against humanity, war crimes. And we need to, explain why those forms of punishment are not only according to international standards, as Camilo explained, but also legitimate, politically legitimate, and are, a way to balance, making peace and being able to sign the agreement and having at the same time justice. And of course, justice is about, having the impression, the society having the impression that justice was done. So actually Lily, who's here as well, was asking this very question, and I think you should work on that, one of your big dissertation questions, and is how you know, how are we going to convey the message of punishment with this very new formula of punishing? So people are expecting, you know, punishment, and we are offering a different form of the usual, ordinary way that people feel, you know, this big criminals should be punished. So it's a challenge in terms of communicating, of, you know, of a new tribunal being able to convey the message that was wrong. Those people are responsible for serious crimes, and they are going to be, you know, seriously punished. So we really need to work. I mean, Lily's working on that in her PhD. Others are very welcome to join the club on restorative justice and conveying a message on serious punishing for, you know, people found responsible for international crimes. So I'll end there. Camila, I don't know if you want to.
Briefly, just on two issues. In the question of sequencing and coordination, I think that's the main challenge. You know, I think at some point the parties at the table were trying to think how they could, you know, millimetrically coordinate and sequence, and they just understood that life happens and there is not much that you can do about it. You know, if the Truth Commission goes first, of the prosecutions goes first, a good argument for one or the other model, but the issue is that the political pressure inside the country was so hard that it is very impossible now to think, because you once you set this process in motion, you know, you don't own them. They are living animals that they respond to different interests, and there is very little you can do if your aim is of complete control. You can still plan ahead and try to influence them, but I think there is something that we have to do once they start, and I think it will depend on so many trivial factors. For example, if we get the administrative via to select first the commissioners, or, you know, if we get the judges first, you know, that is not part of a big plan, but sometimes you have to deal with that. So that's why I think this is, as Catalina mentioned, a 15, 20, 30-year task, and it has to be understood as that. Second, about the spoilers, and your question of who's going to pay for this, because I understood it was Soros, but now that, now that you're mentioning it, no, it's a...
Can be interpreted as an offer of
No, I think sometimes I ask myself, why now an agreement if we've been trying to do it for 50 years? And the most cynical answer is that because the elites at some point decided or thought that this was the good time to do it, or the last time to do it. On the guerrilla side, you know, if you look at them, mainly they're all the leaders. It's the oldest guerrilla, Marxist guerrilla in the world. It is like Grandpa Convention. You know, it was the only, and that's maybe the last time for them to honor the idea of a political fight, because they know the all layers that came after that have been childs of the war. They didn't have that idea, so it was the only and last exit honorable for them to do. That might be the case. And for the elites, the political elites of represented in government, sorry Catalina, but and the economic elites, I think, because, you know, in the past our economic focus was in the middle part of the country. You know, we were the growing coffee economy, and now we are trying to make our living out of commodities that are in those rural areas that were controlled by the guerrilla. So it's good for business. Peace is good for business, and I think was very attractive, and that to me makes them the biggest spoiler right now. I think at this point is not the army, and it is not Uribe's party. Uribe is the former president that was mentioned here, and because I think somehow they will adapt, because everyone there adapts. There is some political figures say that I don't know how to translate it, but they say something like, you know, politics makes you constantly change. You know, so they change and they adapt, and I think they will adapt. And I think mainly the army is on board. But what I think is that the economic elites that made the conflict profitable are the ones that are, you know, lurking around, and they say, okay, if this gets to the level of reconciling with a guerrilla, bringing them back to society, I'm fine. But once this starts, you know, growing, if it grows, then I think we'll have the spoilers, and they will be major spoilers. So how to do it is very difficult. I think for the combatants, we have a technical challenge to make it work. We won already the political battle, as Catalina mentioned. I think with the others, we are yet to start the political battle. And I think that's a big challenge. And I think you're not betting on, you know, spoil with the usual means of it, you know, putting some bombs before the election or something. That I hope that will not be the case. But you're betting not on a sudden death of the political process or the peace process, but that of its dying, you know, away one piece by a little piece at a time, you know, just saying that 10 years along the way, oh, it didn't work, but people just move on. So that's how you're betting on being spoilers, I think, as of now. So that's why it's very important for you to come tomorrow. Because the real challenge now. Thank you.
Do we have time for another round of questions? Yeah? Okay, so I think one more round of questions. Lots of questions. Michael, Paula, okay. I've seen 4, and I think with that we probably, okay, I've seen 5, but with that we really have to finish. So Michael first.
Okay. So thanks for your presentations, Catalina.
You have to speak up. Even I can't hear you.
Just one question, which was one of the points that I asked myself when I looked at the new jurisdiction for peace. It's obvious why you have benefits in there for the guerrilla groups, because you're trying to disband them, you're trying to achieve that they disband and disarm. However, you also have other groups in there with which you are not actually negotiating. You have the third parties and you have the state representatives who also committed very severe crimes. So my bit provocative question is, don't you have in this glossy, new, shiny and progressive package, don't you have some regressive elements in there? For instance, why should a member of the military get a special sanction for the murder in cold blood of civilians? Because a murder in the domestic system is punished by 20, 30, 40 years maybe, and but a member of the army will get up to 8 years for the murder of a civilian. The same for third parties. In the domestic system, they will usually get a very high sentence for the participation in, for instance, war crimes or crimes against humanity, but under the special jurisdiction, a lower sentence. So you could say that, well, you want to provide an incentive for them to come out with the whole truth, but these incentives also exist under the domestic system. When I say domestic system, the regular criminal system. You can get a 50% discount in your sentence if you accept the charges, for instance. So could you explain, for the benefit of those present, a bit more why you include those groups with which you are not directly negotiating? Thank you.
Paula.
Thank you for your presentation and your reply. My name is Paula Limon. I work here as a researcher at the university. I have a million questions, but I will make only 2. And one, I would apologize. I mean, you can feel free not to answer. I asked these questions to Dr. Uprimni a few months back when he was here, but I would love to have your take on it, Catalina. One is how, and you already mentioned that you asked us, how is the special jurisdiction for peace different from the justice and peace law? Aside from the fact that it is a special jurisdiction, that there are these judges, international, etc., I feel in terms of capacity, how is it going to be implemented in a way that it doesn't collapse?
Okay, but that will be here until tomorrow. But
I know, that's the one that
you can pursue this over drinks later. But
exactly. And the second one would just be a few months back there was this, as far as I knew, I'm not Colombian, a non-negotiable point on the table, which was the fact that this agreement was going to be passed or approved either in plebiscite or as a constitutional assembly. The FARC wanted a constitutional assembly, and the government said no, it's plebiscite. And apparently for both parties this was a non-negotiable point. I don't know if this has changed, or how do you see this issue unfolding now?
You answer the question, Gwen.
Yes, thank you. Thank you very much also for your presentations. It was really interesting, both of you. My name is Gwen Banyard. I'm a lecturer in political anthropology in the National University of Colombia. I have three very concrete questions. First of all, you've mentioned a lot the role of international corporations and responsibility, and the fact that the Special Tribunal for Peace allows for the recognition of responsibility by transnational corporations, among other third actors. And I wondered, in the whole system of the peace accords in general, has there been discussion, what is the possibility of one of the mechanisms of reparations being the contribution to the land fund specifically? My second question, I was really glad, Camila, that you mentioned the report by Human Rights Watch. I was very shocked by the report, not only in terms of political irresponsibility, I think, but also out of touch with current trends in transitional justice. And I wondered, seeing as we're in a room full of experts on transitional justice, is there room for perhaps updating that report in light of, you know, privileging this kind of absolutist look at criminal law over transitional justice, which has kind of broader goals? And also, has there been any proclamations publicly by the General Prosecutor's Office of the ICC regarding the agreements from December? And finally, I wondered if you had anything to add on the possibility that the ELN will be able to participate in these same agreements.
Okay, two more questions and then we need very brief answers, I'm afraid. Yeah.
Thank you so much for your presentations. I'm Alicia Bampitas. I'm doing the LLM here at Essex. I was really interested in the FARC's insistence on the including civilians who aided or abetted the paramilitary insurgents groups. And I was wondering if the special sanctions for full truth and acknowledgement also extends to those civilians, and also your reflections on the contribution of the inclusion of those civilians to achieving the goals of transitional justice in terms of non-repetition, justice, and the seeking of truth.
Okay, final question.
Thank you. All these questions are really difficult. So mine is equally difficult. No, but it's about this idea of collective responsibility, which was really interesting in terms of after acknowledgement of responsibility is made public, then you said that one of the elements of the concluding resolution, I think, might be that that there is a acknowledgement of collective responsibility, which might lead to collective restorative tasks, kind of like, for instance, construction or reconstruction of infrastructure. That sounds to me very innovative and interesting, and if you can expand on that, how can collective responsibility be acknowledged? What might be the process? If you can say something more about that.
Okay, lots of challenging questions to finish an interesting day with.
And then the rest in the room, because it's like we were going to.
Okay, so keep it. Yeah.
Very
Pick and choose your questions you want to ask. The rest can be done over drinks next door.
I will just answer the easy ones. The difficult ones, Camila will answer them. So quickly, on Michael's question and why opening up the special jurisdiction and the special sanctions for both state agents and third parties when the negotiations didn't involve them. I think it's critical for the stability of the peace agreement. I mean, it's really critical if we want to look this in the terms of this is about finally being able to finish the war. We really need to have on board those who might become spoilers, but we really need to have on board all the ones who have participated in the war. So for me, actually, one of the biggest achievements is by now, listening to the people at the Ministry of Defense and my colleagues there, and officials, high-ranking officials at the Ministry of Defense, understanding the agreement and citing the clauses, and we will do this and this and that, and this works like this, and really being part of the transitional justice arrangement, because I really prefer having them on board for the sake of stable, lasting peace, for the sake of, being transitional justice serious about this is legitimate because it leads to the end of the war. And this time, previous times in Colombia, as you know, of course, amnesties were only granted for guerrillas. The same with the special peace and justice procedure. It excluded expressly state agents and third parties. So that gave a very partial picture on what happened. It was a limited truth. Even though it was important, and I can send those of you who are interested, a paper I wrote in Spanish on the lessons we have to learn about the peace and justice previous proceedings. But now, for me, it's critical to have them. In terms of, very probably rude and pragmatic realpolitik answer, it would be they will otherwise become spoilers. On a more, which is my take, legitimacy and goals of transitional justice is crucial to have them on board. So with regard to third parties, who was asking about that, you're very welcome to come tomorrow. That will be there, and I won't, mention all my points, so I don't have to. But just quick things about clarification. The jurisdiction is about establishing individual criminal responsibility. We don't have corporate, criminal responsibility, and there is not in our plans for the time being to change the domestic legislation through the special jurisdiction for peace to include, certain form of corporate criminal responsibility. So we are limiting to individual responsibility. But before the Truth Commission, it will be the case that more political corporate responsibility will be discussed, and that's the idea. So the challenge, as I mentioned before, is how to translate that, those findings into a contribution for reparations. There is a general clause in the reparations section of the agreement that the government should find a way, encourage those third parties to contribute to reparations. It doesn't say which is the procedure, so we're working on that. So how it is different from the peace and justice scheme? In several ways. First of all, and I will give just 3 quick comments. With the peace and justice proceedings, were adopted a very ordinary form of criminal justice. The phases of the procedure were basically the same, and everybody, 5,000 people applied to get, to go to the peace and justice proceedings, and everyone was supposed to get a final sentence. After 10 years, we have been able to sentence only 168 people in 38 final decisions, and 1,700 people are still in prison waiting for trial. So now with the jurisdiction, the special jurisdiction, the idea is to be much more effective in the way that we approach, the criminal justice, and offer not only the getting to the final point, getting to the sentence as the only mechanism to resolve your legal situation, but offering other ways, which include amnesty, for those crimes that are amnestiable, or possible to grant amnesty, and this is really something we need to work hard on, the other forms of resolving your legal situation, which include renouncing to the exercise of jurisdiction for those, for example, who are not the most responsible of some crimes. We will need to, because this system and the jurisdiction will need to solve the legal situation of 20,000 people. And these numbers come from the Office of the Prosecutor General, the ordinary Office of the Prosecutor General. They, already gave us, the Ministry of Justice, the numbers of people who have been investigated, prosecuted, sentenced in Colombia, many of them in absentia, others are in jail, others are, somewhere. And those people are the ones who are going, of course, to apply for the jurisdiction. Those people, the guerrillas and the state agents that see an opportunity to solve their legal situation through the new system. So the jurisdiction will need to, offer different forms of different alternatives, and not only going through the entire procedure, because that will make, as you will put, the system to collapse. So I won't really go into all the detail about endorsement. So there is an agreement on endorsement. In that agreement, it was included the idea that the agreement, the final agreement, should be signed as a special humanitarian agreement and should be adopted by law, and then it should come into the Constitution. It will have automatic constitutional review. It's a very complex, intricate, but just to answer quickly, yes, that the issue was solved. Yes, there is an agreement on that, which is very, very important. That's why people are saying this is really the end. The final peace agreement is coming, because the other very difficult issue was tackled and was resolved. And I can explain to you afterwards. I think, I know, just on collect, just quickly, but I think probably I explained it when I read the presentation. I went too quick over that point. And, actually, the FARC wanted just collective responsibility. No? It's easier. It's easier to go with your group and say, it wasn't me, it was us. It was us as a group, it was us, these are our, principles, practices, and of course, we pushed very, very hard, and that's why it took so long to get, this is about individual responsibility. The tribunal will need to establish individual responsibility, and the way we managed was, okay, the act of acknowledgement could still be collective, but the tribunal would need to, and the chamber, acknowledgement chamber, will need to individualize responsibility. So they can still, for example, appear, I don't know how, we will need you designing the performance. Luis Carlos is a performance expert and professor at a university close by. We will need to design the performance of the guy saying, I don't know, I was responsible and I am part of this collective, and how to, play around the idea of having them collectively acknowledgement, but attributing individual responsibility for international crimes. Plus, which I think it's really very important, they wanted it to be in writing. Of course, it's easy when the lawyer writes, you know, with this and this and that, and this is our bylaws or whatever. But we wanted it to be in public. So we managed to get both. You know, the chamber can make the decision to have it in public, the person acknowledging responsibility. That leads me to just the final word on, we will need to be very strategic on choosing who we want to, you know, be doing this hearing, acknowledging responsibility. Not to do 1,000 of them, you know, 20,000 of them, but very strategically choosing who is going to appear there, for what crimes, for what regions, in a way that we can illustrate the entire, you know, map of violations, regions, phenomena.
Okay.